Please, your lordship, in this matter, my lord, I am appearing for the UDA, my lord.
Yes.
Lord, my submission is that this petition is not maintainable at all, my lord, because his grievance has already been redressed by this honorable court as well as by the learned trial court, my lord. What happened, my lord, that we had granted a lease in favor of someone else for residential purpose, my lord. Subsequently, we found that the terms and conditions of lease have already been violated, and therefore, my lord, we issued so cause notice. After so cause notice, my lord, we sought explanation, and thereafter, my lord, lease deed has already been cancelled. Now, my lord, we have issued a notice in 2023, the so cause as to why this should not be demolished, my lord. This notice has been challenged in trial court as well as before the Honorable High Court also, my lord, and that has already been decided, my lord. Now, my lord, he is taking the grievance that this notice has been issued by the authority who is not competent to issue that, my lord, because this has been... I'm sorry, my lord. Lord, his grievance is not very short. That the CEO or Ujjain Development Authority has issued the notice, my lord. He has simply issued the notice so cause as to why action should not be taken against you, my lord, because lease deed had already been cancelled. Against that, my lord, they approach this honorable court under 226, my lord. My submission is this is not maintainable. If he has any grievance, my lord, he may go there and file his response. He has simply sought the response from the petitioner side. This petition is actually premature petition, my lord.
Here the lease was cancelled.
Yes, my lord, has already been cancelled. He has filed the civil suit. Civil suit is still sub judice. He has also filed Order 39 Rule 1 and 2 application that has been rejected. He filed appeal that has also been rejected, my lord. Nothing survived so far as the present petition is concerned, my lord, at this stage.
There is some order of some writ petition also?
Yes, my lord, they have also challenged. Yes, Mr. Kaustubh.
Annexure P9. What is Annexure P9?
Annexure P9 is in notice.
P9 is ordered in some writ petitions.
That was the earlier order.
Earlier order.
Yes, ma'am. In that, they have came up before this honorable court against the termination of lease. So the honorable court has directed them to go and file before forum. So they filed a civil suit against.
And in the civil suit, my lord, they have also filed a temporary injunction for temporary relief. That application has already been dismissed. Against that, they have approached the first appellate court. That has also been rejected. And now, your lordship may kindly see the language of the notice, my lord. Simple in explanation has been sought. Nothing more is there. If he has anything not there, if he has any grievance, that he may go there.
Yes.
Before my learned friend starts, may I just make a judgment request? There are different sets of petitioners. There is a set of petitioners who have approached this honorable court in the miscellaneous appeal. Those appeals are pending before the coordinate bench, and there is already an order of status.
Again, rejection of relief.
Yes, there are certain petitioners, my lord, who have raised dismissal by this honorable court, the previous petition. And my lord, these are the petitions, my lord, arising out of the impure notices, my lord, under 240. And my lord, as per my instructions, my lord, it's a genuine request, my lord. A few of them have approached honorable apex. And my instructions are set, my lord, that the matter is likely to come up, my lord, in a week or so. And the Supreme Court is now seized of the matter, my lord. I do not have
Against what was the miscellaneous appeal?
Miscellaneous petitions, my lord, dismissing my or affirming the order of miscellaneous appeal.
That is arising out of the civil.
Yes, my lord.
Right and personal.
Yes, my lord. So, my lord, yes, my lord. So, civil court is also seized of the matter. And my lord, instructions are such, my lord, that the parties have approached me.
This is entirely civil.
My lord, in the fitness of the things, my lord, in my respectful submission, if your lordship defer this petition for a week or so.
Right. Your lordship is entirely.
No, my lord, your lordship may be pleased to see, but that this notice is arising out of the cancellation of peace. That is under question, Lord, before the Supreme Court. I sought for an injunction that was declined. The miscellaneous appeal was also dismissed, and the eventually petition was also dismissed. Now, my lord, assuming, my lord, for a moment, Lord, that this honorable apex court grants them a status quo or stay of the order. But virtually this petition will have to be kept in abeyance.
And has this petitioner approached the civil court?
Yes.
All of them.
Lord, what was in my respectful submission, Lord, this notice is a byproduct of the cancellation of this. And assuming, my Lord, the Supreme Court grants stay, my Lord, the very, my Lord, the genesis of the matter, my Lord, because this is a byproduct. Because of the cancellation of this, my Lord, they have invoked the powers under the NIAM 2012.
So when is the matter coming up before the Supreme Court?
My Lord, my instructions are said that in a week or so the matter is coming.
Expecting for a week also.
Lord, for weeks, my Lord, because
You'll be protected for 3 weeks. No action will be taken against you.
Lord, may I make a simple submission, my Lord?
Please let me
If
complete.
my learned friend's submission is my Lord, treated to be true for the sake of arguments, my Lord, still this petition is not maintainable. Your Lordship may kindly consider if he has any grievance that he wants supreme protection, he may mention before the Honorable Supreme Court. Because your Lordship may kindly say what is the issue in this writ petition, Lord? Issue is very simple. Your Lordship may kindly see the operative portion of the impugned notice. In impugned notice, Lord,
and in the eventuality, any order is passed, but either in favor or against it. And if the Honorable Apex Court grants me stay, virtually this notice will come to an
he
end.
may also file an application before the competent authority saying that my
This will not be a trouble.
petition is pending there, and you please kindly protect us for.
is issued pursuant to
Cancellation of fees.
pursuant to rejection of your injunction. Then it must have been issued.
My Lord, actually this notice was issued even during the pendency of my. So there is no question about.
Yeah, it's in a suit itself.
My Lord, the very cancellation of fees is under challenge.
And this notice
Is based on the cancellation of this.
This also you can challenge before the Supreme
No,
Court.
my Lord, I need not, my Lord. Reason being, if the
Civil court wants civil suit.
no, my Lord, if
All suits are challenged.
no, my Lord, just a moment, my Lord. If the civil court comes to a conclusion that the lease was wrongly cancelled, now what would be the status of this very impugned notice? And what if, my Lord, if the Honorable Apex Court grants me a stay, my Lord? Then again, my Lord, the very cancellation will come to a halt.
Now, what happens if the SLB is dismissed by the Supreme Court?
Then we will argue this matter, man.
What happens to the civil suit?
The civil suit will go on, my Lord. Therefore, I am requesting, my Lord, that civil court is seized of the matter only to the extent whether the lease was cancelled rightly or wrongly. Now, in case, my Lord, for the purposes of granting the injunction or not, if the Honorable Apex Court protects me, the effect of that cancellation of lease, my Lord, because this matter, my Lord, is before your Lordship, it's not there before Apex Court. If, my Lord, assuming, my Lord, that the Honorable Supreme Court protects me, the effect of this notice, my Lord, will automatically come to a halt. So therefore, my Lord, in my respectful submission, it will not be a problem for.
Can I just make a small submission since it's not? Irrespective of the fact what happens to the civil suit, whether or not cancellation is right or wrong, whether or not my temporary injunction application is dismissed, or if it is allowed, then definitely this goes off. But even if it is dismissed, the question is, what is the due process of law whereby you can take possession of this property from me? Now they have issued me a notice under section 248 of MP Land Revenue Code. This notice is the provision of section 248, my lord, and the power is given to the Tehsildar under MPLRC. Now the question which arises is that how this power can be exercised by the Chief Executive Officer of IDA. And secondly, my lord, if at all this power under section 248 can be delegated to CEO. Thirdly, what would be the modus operandi to delegate this power to the CEO? And fourthly, my lord, can the state framing rules while exercising power under section 85 read with section 58 of Town and Country Planning Act frame this kind of a rule wherein the power under a legislation is given to Tehsildar, where it
Challenge here.
my
Rule is not challenged here.
my humble submission is, what I am submitting is that anything which is without jurisdiction, even it comes as an incidental or a corollary thing, I can always allege it.
That applies to orders, not to rules. Acts. It doesn't apply to that.
My humble submission is
Without jurisdiction will be an order, not a notification or an act or a rule. No one can say that this particular act is without
my humble submission is, that it is a state government who has framed this rule. A state government is like any other authority before this honorable. It's a litigant before this honorable body. So
it's like a powers also.
But when I'm talking about
By the Constitution.
my humble submission is, when I'm talking about there are three pillars, one is executive, judiciary and legislature. State has contours of executive also and a legislature also. What I'm trying to submit before this honorable court is that while making these rules, state is exercising contours of executive, not legislature. My lord was exactly right if I would have challenged something which was done by the state while exercising legislative power.
Rule making
is not a legislative power. It is and so it is a legislation, my lord. It is a subordinate legislation.
There is a legislation. Rule made under the act is not legislation.
My humble submission is that today MP Land Revenue Court is a legislature. Just bear with me for a moment. It says that it's under section 248 is to be exercised by Tehsildar. Now, by way of a subordinate legislation, it says exercise this power to see you. There are judgments to the effect that if section 248 is exercised even by the collector, the court has said no, you can't do it. Right? Because this, by way of legislation, this power is conferred only by the legislature. Why am I saying this? Is because if that is not the case, then you rely back on Ujjain Das case, wherein the court has said that you need to take possession even after termination of life by due process of law.
Bring that up.
सर मैं
जिस दिन मध्य प्रदेश विकास प्राधिकरण की संपत्तियों का प्रबंधन निगम द्वारा संशोधन 2020
Sir, what I'm saying is that I'm not challenging the virus of anything. I'm saying is that this delegation is an excess of power which cannot be done by the state.
The act itself gives power to frame the rules.
Yes, sir.
The rule is framed in exercise of rule-making power. It is rules made up by the act.
Sir.
And by the notification, how can this be an executive act framing of rules?
Madam, but even if it is not exactly an executive, it is a subordinate legislation. Rule, but it will not have the impact of a statute.
Even a subordinate legislation cannot be said to be without jurisdiction.
What I am respectfully submitting is that something without jurisdiction, whether it's a decree of the court, whether it's an action, whether anything, which is a nullity from the very beginning. What I am challenging is the very jurisdiction to delegate this power to the CEO.
Jurisdiction of whom?
Of the state government, in contradiction to the statute of MP Land Revenue Code. This is my second point of argument would be that no one can be a judge in his own cause. This will be the 2 points of arguments in this matter, Manu.
Any other submission?
Manu, so my first submission is, Manu, in respect of section 248 delegation, Manu, that says the MP Land Revenue Code confers this power on the Tehsildar. by framing rules under section 58 and 85, this power cannot be delegated to the CEO. And therefore, this process of law, which is adopted by them, is completely without jurisdiction.
Land Revenue Code is also state legislation. Nagartala Gram Nivesh Adhiniyam is also state legislation.
Sir, but
Neither of them could exclude the other.
sir, but the rules which are framed,
In fact, there is no non-obstructive clause.
sir, there is no non-obstructive clause, but you, sir, it is like this, that I give in a statute a particular power to a particular authority. Then there comes the rules under some other act, that conferring that power to someone else.
Is there any prohibition?
Sir, when this farmer, sir, they could have very well framed a rule saying that CEO has the power to issue notices, take evidence, and after giving opportunity of hearing, throw them out. Yes, I would not have challenged. What I am submitting is that when a particular provision confers a particular power in a particular authority, can you, by making a rule under some other act, confer that power on some other authority in violation to that rule? This is my submission, my lord. Sir, अगर ये रूल ऐसा फ्रेम होता कि जो भी प्रॉपर्टी आईडीए ने लीज दी है उसको सीईओ नोटिस इश्यू करके एविडेंस लेके फिर डिस्पोजेस कर सकता है, तो that would have been an appropriate rule. I could not have challenged it. But my lord, kindly read the rule. It says that the powers be delegated. My lord, have a look at the rule, section 35, my lord. Rule 35. The CEO will be the competent authority for removal of unauthorized possession from the property of the development authority using the powers delegated under section 248 of MPLRs. So, my respectful submission is that this could not have been done by merely framing rules under section 85 read with section 58. And therefore, sir, this action is completely without jurisdiction, and the appropriate step is to file a suit and take possession. And on this, on this particular point, then there is a second point is, my lord, that this lease has been terminated by the CEO.
That you say before the Supreme Court.
Yes.
But now since I am going to suffer an irreparable loss by way of disposition, I will have to point it out to my lord.
Is refused by 3 courts, including this court.
My lord, kindly have a look at only one judgment. That's the only second line which I have.
One option is to file the reply and let them decide. 48. Then you can be protected.
My lord, para 13. Para 13, my lord, Mary. Just one paragraph, my lord, that's it.
Yes.
My lord. In this connection, reference was made to the case of Delhi Financial Corporation, Adar versus Rajiv Anand and others. Reported in so with regard to personal bias, an officer of the statutory authority has been appointed as an estate officer. Therefore, they will carry their personal bias to this court in the aforesaid case. As that a doctrine, no man can be a judge in his own cause, can be applied only to cases where the person concerned has a personal interest or has himself already done some act or take a decision in the matter concerned. Merely because an officer of the corporation is named to be the authority does not by itself bring into operation the doctrine. No man can be a judge in his own cause. For that doctrine to come into play, it must be shown that the officer concerned has a personal bias or a connection or a personal interest or has personally acted in a manner concerned, has already taken a decision one way or the other which he may be interested in supporting. I'm following in the last clause, my lord. So, my lord, these are the two grounds on which I assail the notice under section 248, because since he has already cancelled my lease, he will be interested in supporting that decision by dispossessing me. And secondly, the powers under section 248 of SLR cannot be conferred, exercised by the CEO. And on this particular point, my lord, there is a matter which is pending before the division bench. honest. So ये दोनों it was listed before in single bench, and then it was sent to DB and it was admitted for final hearing.
Till and unless it is struck down, remains to be a valid legislation. Just because some rule has been challenged and the petition is pending, that rule should be taken to
But that is not my submission. My only submission is that this
I
confer then the third line would be, my lord, that I may be permitted to file reply and given a due opportunity of hearing, and if any adverse order is passed against me, then I should be protected for that sufficient time so that I can adopt the due remedy under the protocol. These are the three lines.
Lord, that has already been given. That has already been given in the impugned notice, Lord.
In pursuance of the impugned notice, they will find the reply. You take
Yes,
it
Lord. They may, Lord. I'm not. Yes, Lord.
They have the right. पहले दिन ही ऐसा डिस्पोज for the necessarily fighting. At
the cost of reputation, Lord, I'm frustrated.
Giving you adequate time to get the order from the Supreme Court. That is what I suggested at the outset. And give you sufficient time to secure an order from the
Yes, Lord.
Yes,
My
Lord.
Lord is very correct. All that I wanted, Lord, to convey, Lord. And what can be done today, this can be done, Lord, even after release.
777-21 days, get an order from the Supreme Court. But under Article 126 of the Constitution of India, the petitioner has challenged the order dated 12/6/2020, Annexure P11. It has challenged no cause protest dated 12/6/2020 for Annexure P11. By starting November 1st. 2. The Estate Officer Ujjain Development Authority Ujjain. Next. If a result of the impugned notice indicates that the same has been issued in exercise of power under Madhya Pradesh Vikas Pradhikaran की संपत्तियों का प्रबंधन एवं व्ययन 2018. तो इंग्लिश ट्रांसलेशन ही यही है. ठीक है.
उसका नाम
वही है. एक एमपी के से as amended in 2021.
Yes.
Of the rule which has been made applicable in full 35 years of stuff. Such rule has been made. Such rules have been placed in exercise of the powers of delegation under Section 248 of the Land Revenue Code 1954. Next, it is observed that the notice has been issued to the petitioner to show cause, and no order has been passed against him. Now he has been given a period of 7 days for filing his reply to the same. So the notice was issued almost 2 months ago. But the petitioner does not file a reply to the same. So, already an order takes 20 months to petition. To the effect that no person action be taken against the petitioner.
which may have which may need.
If whether the available facts of the case or not, it would just appropriate for the petitioner to file. It's a reply to the show of notice within a period of 7 days from today. So thereafter, he shall be afforded the opportunity of hearing by the respondents. And upon Thursday, is to reply. The final order in the matter shall be next. So in case the final order is petitioner opted the same shall be kept in abeyance for a period of 7 days. Or in evening, same the same in accordance.
At least 2 weeks.
15 days is enough, Lord. It's a notice of June.
At least 2 weeks.
Also 14 days, sir.
7 days.
बहुत कम हो जाए actually.
एटलीस्ट
बहुत मैंने एटलीस्ट रिप्लाई तो देगा आपका
नहीं, मेरे इसमें तो फाइल है रिप्लाई,
सर मेरा
मेरे इसमें तो रिप्लाई फाइल
फाइल है
जी। आपके
इसी
इसमें
नहीं करते
if any
तो एटलीस्ट 7 महीने के
तो
फॉलो
एक सब तो अलग अलग करो 30 is coming up for the first time
30 is coming up.
उसमें कोई इंटरनल मॉडल
इसमें कोई इंटर मॉडल नहीं.
ठीक है
Lord, interim order is extended till the disposal of the reply.
So we under 248 sir evidence भी लीड करने का opportunity मिलता है.
जो लीगल इशू प्लेस किए उसमें क्या है अरे उसके
Then
लिए
actually, Lord, encroaches.
अपलोडिंग क्यों अपॉर्चुनिटी आपने
And leading evidence.
कोई टाइम फिक्स किया नहीं
उसमें hearing है leading evidence पे आ रहा है.
opportunity of hearing means
ठीक है सर grateful.
Deeply obliged.
I can say